This particular case is a stark reminder to employers to ensure that you act responsibly and that you treat your employees with respect and have appropriate understanding for them too. In this particular case I'm going to talk about, it concerns an employee who brought a claim for religious discrimination and unfair dismissal. And he was a Jewish employee, and he effectively was dismissed because he couldn't come to work during Passover. He was a litigation executive who worked at a firm called NNE Law Limited, and he was told to attend the office irrespective of the fact that he had booked annual leave during the late period of April 2020 in order to observe his religious obligations concerning the Passover. Now, the law firm had a policy in place whereby they were able to cancel leave later on after one has been on sick leave if it was over a 2-week period, because they didn't allow their employees to be off for more than 2 weeks. To begin with, after lockdown was instigated after March 2020, the firm had nonetheless asked the claimant to come into work. The claimant did come into work, but he fell ill and he was advised by the NHS to stay at home. That period lasted around 2 weeks. The following 2 weeks were for the annual leave that he'd taken off. Now, the employer nonetheless cancelled his annual leave and told him to come in. The employee said that he wasn't able to come in because of his religious obligations in order to keep the Passover and not attend work. In response, the employer said it had no choice but to let him go, but to dismiss him, and so it did. So Philip Bialik, who was the claimant, then brought claims against the employer, as mentioned, for religious discrimination and unfair dismissal. And it was indeed decided that, first of all, there were no urgent client needs to be met. There weren't been any court deadlines that the claimant would have to meet. But in any event, there was discrimination there because the policy to cancel employees' annual leave in such a way meant that it put Jewish employees at a disadvantage compared to non-Jewish employees, and this scenario spoke for itself. So there was certainly indirect discrimination there, and that's where a company may have a policy, a practice, or some kind of criterion which may treat a particular group of people with a protected characteristic less favorably than others. And certainly where there's no legitimate aim to be proved, then indeed it will be found to be discrimination. And that's exactly what happened in this particular case. And that's why he was awarded around £26,500. So again, often discrimination isn't so blatant, and often discrimination may be found hidden within policies, like this particular scenario. So it's not the case that employers go out of their way to discriminate against people. Of course that's not the case, or dare I say, ought not to be the case. But I think employers need to have a douse of common sense here, and also need to ensure that they do act reasonably and sensibly and have a degree of understanding toward their employees. And they'll certainly avoid scenarios such as this. If indeed you are an employee in this particular capacity, get in touch. Let's talk. We'll be more than happy to help.